Greetings. Hi, everyone. How are y'all doing? Greetings. Yes, it's so good to see you all. Listen here, let me make sure that you all can hear me. Please let me know if you can hear me. Sound check. Sound check. Can you hear me? All right. So, Smokey Robinson responds, vile allegations uncovered. In this video, we delve into the recent SA allegations against Motown legend Smokey Robinson. Robinson has firmly denied these claims, with his attorney, Christopher Frost, asserting that the allegations are an attempt to extort money from the iconic artist. Frost highlights inconsistencies and questionable timelines in the plaintiff's accounts, raising doubts about the validity of the accusations. Additionally, we discussed the allegations against Robinson's wife, Frances, who has been accused of fostering a hostile work environment. Join us as we explore the details of this unfolding story and its implications for Robinson's legacy. All right, so we'll be diving into the court documents on this evening. You all, please make sure you like, share, and subscribe. Please, 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 and let somebody know that we are live. Okay, here we are. Okay, yeah, here we are. All right, so without further ado, let's go ahead and get into the lawsuits. And this is going to be actually my first time reading it. I have not heard about it. I know that other content creators have been out here covering the story. However, it's new to me. But there has been conversations going on. And, I heard, like, I guess somebody in the lawsuit stayed around or something like that. And I wanted to say this because when it comes to like the Cassie's lawsuit, I know like a lot of people, they're like, oh my gosh, she should have left and this, that, and the third. But sometimes, you know, they just can't leave, or like the person will like, love bomb them and act like, that they're going to be a changed person, and they didn't mean it, so they will give excuses like the alleged person, um the what would you call it, the abuser, right? The abuser, sometimes the abuser will sit there and he will act like, oh, I'm sorry and I will never do this no more, and it's going to be like the same thing. And they say sometimes, if he'll hit you once, then he'll hit you again. So we definitely have to protect ourselves. All right, so let's get into it. Let's go ahead and bring up the documents. We do have the court documents right here. All right. Excuse me, you all. Okay, so what I want to bring up is the court documents, and this is going to be the court documents from the case. Okay, and so it has all that information up on there. Let's see, let's see, let's see. Okay, I'm not really sure if y'all can see that. Um, Here, I'll do this. Oh, that's not good. Okay, so let's get into it. So I'm going to read from the top. Okay, so it says State of California Superior Court of Los Angeles. Attorneys for the plaintiff. There's other information up there. So it says Jane Doe 1, an individual Jane Doe 2, and an individual Jane Doe 3, and individual Jane Doe 4, and individual. Those are the plaintiffs. Now, um, versus William Robinson Jr., aka Smokey Robinson, and individual Francis Robinson, and individual, and those 1 through 25 inclusive defendants. All right, so their complaint is going to be for complaint for damages, negligence, battery, um, assault, false imprisonment, intentional infliction of emotional distress, negligent infliction of emotional distress, gender violence, Ralph Act, Bain Act, hostile work environment, constructive discharge, and violation of FEHA, failure to pay minimum wage, labor code, failure to pay overtime, labor code, inaccurate wage statements, labor code, failure to provide rest periods, labor code, failure to provide meal periods, labor code. Okay, so it says plaintiff Jane Doe's 1 through 4 inclusive, hereinafter referred to as plaintiffs, are individuals in their complaint against defendants William Robinson Jr., aka Smokey Robinson, and Francis Robinson, hereinafter referred to as defendants and or defendant Smokey Robinson and defendant Francis Robinson. In those 1 through 25 inclusive, complain and allege as follows the parties. 2. Plaintiffs are, and at all relevant times mentioned here, and where were individuals residing in the county of Los Angeles. Within the state of California, plaintiffs are adult females suing under placendums to protect their privacy because it involves S misconduct by defendant Smokey Robinson. Upon information and belief, defendant Smokey Robinson is, and at all times relevant times mentioned herein, was an individual doing substantial business in the county of Los Angeles. Within the state of California, employed the plaintiffs and each of them and caused injuries and damages to them in the county of Los Angeles, state of California. Defendant William Robinson Jr. is a legendary American R&B and soul singer, songwriter, record producer, and former record executive, and renowned entertainer. He was the founder and frontman of the pioneer Motown vocal group, The Miracles, for which he was also chief songwriter and producer. Defendant William Robinson Jr. is best known by his stage name, Smokey Robinson. Defendant Francis Robinson is defendant Smokey Robinson's spouse and was also at all times material herein plaintiff's employer along with Smokey Robinson. The true names, identities, and capacities, whether individual, associate, or whether individual, associate, corporate, or otherwise, of defendants those 1 to 25 inclusive, are unknown to plaintiffs. who therefore sues these defendants by such fictitious names pursuant to Code of Civil Procedure 474. When the true names and capacities of such fictitiously designated defendants are ascertained, plaintiffs will amend this complaint to insert their true names, identities, and capacities together with the proper charging allegations. Plaintiffs are informed and believe that each of the defendants sued herein as those are responsible in some manner for the events and happenings alleged in this complaint, and thereby legally causing the injuries and damages to plaintiffs as set forth in this complaint. So, complaint for damages. Plaintiffs are informed and believe that each of the defendants herein was at all times relevant hereto the agent, employee, employer, subsidiary, parent company, representative, and or co-conspirators of the remaining defendants, and was acting at least in part within the course and scope of such relationship. Okay, so jurisdiction and venue. This court has proper jurisdiction over this action pursuant to Code of Civil Procedure 410.10. Plaintiffs allege that the amount claimed is in excess of the jurisdiction minimum of this court. Venue is proper in this court pursuant to Code of Civil Procedure 395A because the location where the incident occurred is within the county of Los Angeles, California. Shout out to Deadline. Excuse me, guys. All right, plaintiff Jane. Okay, so here we are with factual allegations. Jane Doe 1. Plaintiff Jane Doe 1, JD1, re-alleges and incorporates by reference paragraphs 1 through 10 as those set forth here in full. JD1 began working for defendants as their housekeeper at their Chatsworth residence on January the 3rd, 2023, until February 2024, when she was forced to resign due to defendant Smokey Robinson's repeated SA and S harassment against her. The first SA occurred in March 2023, and it continued until her forced resignation in February 2024. JD1 worked on the weekends for the defendants when the rest of the staff was off. On a typical Saturday, defendant Smokey Robinson would take defendant Francis Robinson to the nail salon and would rush home, knowing that he would be home alone with plaintiff JD1. Upon returning home, defendant Smokey Robinson would call her into his blue room, lock the door, and escort their dog, Shiloh, out of the room. He would have showered and clothed only in his underwear. He would then neatly place a white towel on his bed, not to soil the bed linens, in preparation for what was about to occur. Complaint for damages. Defendant Smokey Robinson would then begin to kiss JD1 in her mouth, neck, and her tatas. Then he would roughly go in the private area with his fingers, orally copulate her to proceed to go inside of her with his excitedness, causing her great pain. Defendant Smokey Robinson enjoyed happy ending in her kulala without using a condom. JD1 would protest and resist his SA, but to no avail. In a desperate attempt to get him to stop his SAs, she would proclaim, "You're married," to which he would casually ignore. Defendant Smokey Robinson, SAJD1, in that manner at least 7 times. The last assault occurred on February 17, 2024, prompting her forced resignation on February 24th, 2024. JD1 was unwilling to report defendant Smokey Robinson's unlawful acts to the authorities due to her fear of losing her livelihood, familial reprisal, public embarrassment, shame, and humiliation to her and her family. The possible adverse effect on her immigration status, as well as being threatened and intimidated by defendant Smokey Robinson's well-recognized celebrity status and his influential friends and associates. Defendant Francis Robinson failed to take the appropriate corrective action to prevent defendant Smokey Robinson's deviant misconduct against JD1, despite having full knowledge of his prior acts of misconduct, having settled cases with other women that suffered and experienced similar SA perpetrated by him. Defendant Francis Robinson also perpetrated a hostile work environment by regularly screaming at JD1 in a hostile manner, using ethically pejorative words and language. During JD1's employment with the defendant, she worked 10 hours per day, 3 days per week, Saturday through Monday. At the rate of $18 per hour, they failed to pay minimum wage or pay overtime wages for the hours worked in excess of 8 hours, nor provided rest or lunch breaks. She would often work holidays for the defendants without being paid the holiday rate. Defendants also failed to provide JD1 wage statements for the hours worked. So there's Jane Doe 1. There's 4 Jane Doe, y'all. Okay, so let's get into let's see, Jane Doe 2. Plaintiff Jane Doe 2, JD2, realleges and incorporates by reference paragraphs 1 through 9 as though set for here in full. Complaint for damages is what we're about to read. JD2 began working for defendant as a housekeeper at their Chatsworth residence in or about May 2014 until February 2020, when she was forced to resign due to defendant Smokey Robinson's repeated SA and S harassment against her. Defendant Smokey Robinson's brutal S advances were constant and even predictable throughout her employment with defendants. Defendant Smokey Robinson's SAs began in the later part of 2016 when they were home alone. He would text message her, asking her to meet him at areas in their Chatsworth residence where closed-circuit cameras weren't located. He would then summon her to either the laundry room or garage where there were no cameras. When arriving, he would immediately grab her and begin to go inside her kulala with his fingers, causing her excruciating pain, and then would proceed to berate her. Defendant Smokey Robinson also forced her into his blue room and make her perform OS on his happy stick. Thereafter, he would proceed forcibly go inside her with his happy stick without using a condom. He would enjoy happy ending all over JD2's face, much to his satisfaction and her abject humiliation. Defendant Smokey Robinson SA'd her in this manner on at least 23 different occasions. Defendant Smokey Robinson would threaten her that if she refused to have S with him, he would make defendant Francis Robinson be mean to her, which she was very capable of being. JD2 was unwilling to report defendant Smokey Robinson's unlawful acts to the authorities due to her fear of losing her livelihood, familial reprisal, Public embarrassment, shame, and humiliation to her and her family, the possible adverse effect on her immigration status, as well as being threatened and intimidated by defendant Smokey Robinson's well-organized celebrity status and his influential friends and associates. Defendant Francis Robinson failed to take appropriate corrective action to prevent defendants like Robinson's deviant misconduct against JD2. Despite having full knowledge of his prior acts of misconduct, having settled cases with other women that suffered and experienced similar SA perpetrated by him, complaint for damages. Defendant Francis also perpetrated a hostile work environment by regularly screaming at JD2 in a hostile manner, using ethically pejorative words and language. During JD2's employment with the defendant, she worked 10 hours per day, 6 days per week, Monday through Saturday, at the rate of $10 per hour, increased to $12 in $12 an hour in 2017. They failed to pay minimum or overtime wages for the hours worked, including those in excess of 8 hours, nor provided rest or lunch breaks. She would often work holidays for the defendants without being paid the holiday rate. Defendants also failed to provide JD2 wage statements for the hours worked. So that's JD2. Let's go ahead and go to JD3. So it's 4 JDs, okay? Are y'all still here with me? Here, let me check the chat and see what y'all are seeing. Okay, let me see what y'all are seeing. We have 111 in the building. Hey, 111, how are you doing, my love? Good to see you. Let's see. Who else do we have in here? Yes. Hey, Randy, how are you doing? We got 111 in here. We got Noah Stoney. Hey. Are y'all enjoying this commentary? All right. Well, we're reading the docs. Okay, so let's go ahead and go back here. It's good to see you all. All right, so let me go ahead and finish reading. All right, so now we're on the Jane Doe 3. Plaintiff Jane Doe 3, JD3, realleges and incorporates by reference paragraphs 1 through 9 as those set forth herein full. JD3 began working for defendants as a housekeeper at their Chatsworth residence in or about February 2012 until April 2024. But she was forced to resign due to defendant Smokey Robinson's repeated SA and S harassment against her. Defendant Smokey Robinson repeatedly S harassed, S assaulted, SA and raped JD3 during most of her entire employment with defendants. Defendant Smokey Robinson would force her into his blue room where after he would perform his ritual of exiting his bathroom nude or wearing only underwear after showering, and then carefully placing a towel on his bed not to soil the linens for what was about to occur. He would then disrobe JD3 and then orally copulate her. Then he would force her to lie face down on the towel so that he could go inside her with his happy stick from the rear. Defendant Smokey Robinson repeatedly raped JD3 in this manner at least 20 times. On one occasion, when JD3 resisted his advances, defendant Smokey Robinson offered JD3 $500 to allow him to go down on her, and offer she refused. When not attempting to go in her, defendant Smokey Robinson would make unwanted advances against her, touching her tatas, her hoo-ha, and kissing on her neck and on her mouth. JD3 resigned her position with the defendants on April 22nd, 2024 due to defendant Smokey Robinson's continued SAs in the hostile working environment she experienced daily. JD3 was unwilling to report defendant Smokey Robinson's unlawful acts to the authorities due to her fear of losing her livelihood, familial reprisal, public embarrassment, shame, and humiliation to her and her family, the possible adverse effect on her immigration status, as well as being threatened and intimidated by defendant Smokey Robinson's well recognized celebrity status and his influential friends and associates. Defendant Francis Robinson failed to take appropriate corrective action to prevent defendant Smokey Robinson's deviant misconduct against JD3, despite having full knowledge of his prior acts of misconduct, having settled cases with other women that suffered and experienced similar SAs perpetrated by him. Defendant Francis Robinson also perpetrated a hostile work environment by regularly screaming at JD3 in a hostile manner using ethically pejorative words and language. During JD3's employment with the defendant, she worked 10 hours per day, 6 days per week, Monday through Saturday, at the rate of $18 per hour. They failed to pay minimum or overtime wages for the hours worked, including those in excess of 8 hours, nor provided rest or lunch breaks. She would often work Sundays and holidays for the defendants without being paid overtime or the holiday rate. Defendants also failed to provide JD3 wage statements for the hours worked. Okay, y'all, so now we're on defendant 3 and we're only on page 7, about to head into page 8. Let me check the chat and see if y'all are still here with us. All right, let's see. And please make sure you all are liking, sharing, and subscribing. And taking the poll as well, and then we do have a goal on our main channel here on our main channel. All right, let me just say hello to you all. I'm still here. I'm just back here reading the news for you. Okay, I'm still here with you. All right, let's get back into it. All right, Jane Doe 4. Plaintiff Jane Doe 4, JD4, realleges and incorporates by reference paragraph 1 through 9 allegations as though set forth here in full. JD4 began working for defendants as a housekeeper at their Chatsworth residence, including being defendant Francis Robinson's personal assistant, cook, and hairdresser in or about October 2006 until April 22nd, 2024. When she was forced to resign due to defendant Smokey Robinson's repeated SAs and S harassment against her. Defendant Smokey Robinson first SA'd her in 2007 when she accompanied him to his Las Vegas home. While there and alone with him, defendant Smokey Robinson forced her into his bedroom and raped her. The essays continued 3 and other places. In or about mid-2019, JD4 was asked by defendant Smokey Robinson to accompany him to his temporary residence located in Bell Canyon to clean. While cleaning the master bedroom, defendant Smokey Robinson showered and returned to his bedroom unclothed with his happy stick up. He then proceeded to pull back the sheets and carefully place a towel down, not to soil the bed linens for what was about to occur. He then began to kiss her tatas, her neck, and proceeded to go down on her. And then he raped her. Defendant Smokey Robinson would often create a situation or seize the opportunity where he would be alone with JD4 at their Chatsworth residence. When the other housekeepers would leave the residence, defendant Smokey Robinson would summon her to his blue bedroom while sitting undressed on his bed. He would then lock the door and place a towel on the bed. After doing so, he would pull off JD's clothes and, against her protestations, push her down on the bed and proceed to rape her. Defendant Smokey Robinson never used a condom during the SAs. Climaxing into JD's like hoo-ha or withdrawing and climaxing all over her body. Much to his satisfaction and her abject humiliation, defendant Smokey Robinson would also constantly admire and touch JD's tatas, kiss her neck, and force his tongue into her mouth. He harassed and assaults continued to the very day she decided to resign her employment with the defendant. JD Ford was unwilling to report defendant Smokey Robinson's unlawful acts to the authorities due to her fear of losing her livelihood, familiar appraisal, public embarrassment, shame, and humiliation to her and her family, as well as being threatened and intimidated by defendant Smokey Robinson's well-recognized celebrity status and his influential friends and associates. Defendant, uh, defendant Francis Robinson failed to take the appropriate corrective action to prevent defendant Robinson's deviant misconduct against JD Ford, despite having full knowledge of his prior acts of misconduct, having settled cases with other women that suffered and experienced similar SAs perpetrated by him. Defendant Francis Robinson also perpetuated a hostile work environment by regularly screaming at JD Ford in a hostile manner using ethnically pejorative words and language during JD Ford's employment with the defendant. She worked 10 hours per day, 6 days per week, Monday through Saturday, at the rate of $15 per hour, raised to $20 per hour in 2018. They failed to pay minimum wage or overtime wages for the hours worked, including those in excess of 8 hours, nor provided rest or lunch breaks. JD Ford would also regularly travel with the defendants, but was never compensated for her time doing so. Defendants also failed to provide JD Ford wage statements for the hours worked. Okay, y'all, so are y'all ready for this? Because now the first cause of negligence. That's what we're on right now. So now we're on to the first call of negligence. Like these ladies, one thing that I can say is it seems like I believe two ladies they quit on the same time. I think it was like April 22nd, 2024. Um, it's a lot, y'all. All right, are you all following along with us? Let us know. Make sure you hit the like button and make sure you tell somebody that we're live. All right, let's get back into it. All right, our next section is first cause of action negligence by plaintiffs against all defendants. Plaintiffs re-allege and incorporate by reference all the above allegations as though set forth herein. Defendants acted negligently and carelessly when they caused personal injury to plaintiffs. Defendants owed plaintiffs a duty to exercise reasonable care. Defendants breached their duty to exercise reasonable care when they caused physical, emotional, and monetary harm to plaintiffs. Defendants approximately caused plaintiffs to suffer economic damages as well as physical harm. Defendants' negligence was a substantial factor in causing plaintiffs' physical and economic harm. Okay. So that was number one. So second cause of action, S battery. Okay, by plaintiffs against defendants Smokey Robinson. Plaintiffs allege and incorporate by reference all of the above allegations as those set forth herein in full. California Civil Code 1708.5 provides a statutory cause of action against a person who commits S battery or acts with the intent to cause harmful or offensive contact with an intimate part of another or intimate part of themselves or acts to cause intimate apprehension of a S battery or harmful or offensive contact of an intimate part. Intimate part is defined as S organ, anus, groin, buttocks, or the tatas of a female. Complaint for damages. Defendant Smokey Robinson acted with the intent to cause harmful and offensive contact with plaintiff's S organs, growing and buttocks. These episodes, as more fully illustrated in the statement of facts, happened on numerous occasions over a period of years. As a direct result of defendant Smokey Robinson, intentional and forceful acts and sexually offensive contact with plaintiffs occurred. Defendant Smokey Robinson touched plaintiffs' entire bodies, including their hoo-has, their tatas, legs, abdomen, lips, and face. Plaintiffs did not consent to defendant Smokey Robinson's contact or touching. Plaintiffs explicitly told defendant Robinson on numerous occasions that they were not interested in his advances and objected to his forceful physical, sexual, and harmful conduct. Plaintiffs were severely harmed and humiliated by defendant Smokey Robinson's conduct. As a direct and proximate result of defendant Robinson's actions pled herein, plaintiffs suffered and continue to suffer economic damages as well as severe emotional and physical harm, humiliation, distress, embarrassment, and anxiety as a result of defendant Smokey Robinson's conduct in an amount greatly exceeding the jurisdiction minimum of this court and subject to proof at the time of trial, but in a sum not less than $50 million. Oh, defendant Smokey Robinson's conduct was willful, wanton, and malicious, with a conscious disregard for plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. All right, y'all. Y'all ready to get into it? Okay, we have the third cause of action, assault by plaintiffs against all defendants Smokey Robinson. Plaintiffs reallege and incorporate by reference all the above allegations as those set forth herein for. Defendant Smokey Robinson acted intending to cause harmful and offensive contact. Plaintiffs reasonably believed that they were about to be touched in a harmful and offensive manner when defendant Smokey Robinson repeatedly forced his fingers and his happy stick into their ha-has, hoo-has, causing severe and excruciating pain. Claimant for damages. Plaintiffs did not consent to defendant Smokey Robinson's harmful and offensive contact with their bodies. Plaintiffs were harmed and offended by defendant Smokey Robinson's conduct. Plaintiffs suffered and continue to suffer severe emotional and physical harm as a result of defendant Smokey Robinson's conduct. Defendant Smokey Robinson's conduct was willful, wanton, and malicious with conscious disregard of plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. Fourth cause of action, false imprisonment by plaintiff against defendant Smokey Robinson. Plaintiff realleges and incorporates by reference all the above allegations as those set forth hereinfore. Defendant Smokey Robinson intentionally deprived plaintiffs of their freedom of movement by use of physical barriers, force, threats of force, menace, and unreasonable duress, including unlocking his blue bedroom door to prevent plaintiff's attempt to flee from his essays. Plaintiffs were harmed by defendant Smokey Robinson's forceful confinement, restraint, detention, including physical and emotional harm, as a result of being trapped in his bedroom while being assaulted by him. Defendant Smokey Robinson's conduct was a substantial factor in causing plaintiffs physical and emotional harm. Plaintiffs were severely harmed by defendant Smokey Robinson's conduct. Plaintiffs suffered and continue to suffer severe emotional and physical harm as a result of defendant Smokey Robinson's conduct. Defendant Robinson's conduct was willful, wanton, and malicious with conscious disregard for plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. Planning for damages. All right, fifth cause of action, intentional infliction of emotional distress by plaintiffs against all defendants. Plaintiffs reallege and incorporate by reference all the above allegations as those set forth here in full. Defendant's conduct was outrageous, despicable, and intolerable in a civilized society. Defendants intended to cause plaintiffs emotional distress. Defendants acted with reckless disregard out of probability that plaintiffs would suffer emotional distress and was fully aware that plaintiffs were present when the conduct occurred. Plaintiffs suffered severe emotional distress, including emotional distress related to being repeatedly SA'd numerous times, spanning several years. Defendant's conduct was a substantial factor in causing plaintiffs severe emotional distress. Defendant's conduct was willful, wanton, and malicious, with a conscious disregard of plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. Sixth cause of action, negligent infliction of emotional distress by plaintiffs against all defendants. Plaintiffs reallege and incorporate by reference all the above allegations as those set forth herein full. Defendants were negligent in that they failed to exercise reasonable care and further acted with complete disregard, causing plaintiffs serious emotional distress, including suffering anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, and shame. Plaintiffs suffered severe emotional distress. Defendants' negligence was a substantial factor in causing plaintiffs serious emotional distress, including suffering anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, and shame. Complaint for damages. Seventh cause of action, gender violence by plaintiffs against defendant Smokey Robinson. Plaintiffs reallege and incorporate by reference all the above allegations as those set forth here in full. As pled herein, defendant Smokey Robinson acted to aid, abet, and or conspire to violate California Civil Code 52.4. Defendant Robinson committed acts of gender violence upon plaintiffs through the use, attempted use, or threatened use of physical force against their persons. Committed at least in part based on plaintiff's gender, these acts resulted in the physical intrusion and invasion of plaintiffs in a sexual nature while under coercive conditions. As a direct and proximate cause of defendant Smokey Robinson's actions pled herein, plaintiffs suffered and continue to suffer economic damage as well as severe emotional and physical harm, humiliation, distress, embarrassment, and anxiety as a result of defendant Smokey Robinson's conduct in an amount greatly exceeding the jurisdiction minimum of this court and subject to proof at the time of trial, but in an amount not less than $50 million. Defendant Smokey Robinson's conduct was willful, wanton, and malicious, with a conscious disregard of plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. Plaintiffs have incurred and continue to incur attorney fees in the prosecution of this action and therefore demand reasonable attorney fees and costs. Defendant Smokey Robinson's conduct was willful, wanton, and malicious with a conscious disregard of plaintiff's rights, privacy, and feelings. As such, punitive damages are warranted. All right, so the eighth cause of action, Ralph Act, by plaintiff against defendant Smokey Robinson. Plaintiffs hereby reallege and incorporate by reference all of the above allegations and so set forth in full. Complaint for, what is that? Complaint for damages. Okay, damages should be by okay, damages, so we on the break. Sorry guys. Alright. So it says, during their scope of employment, defendant Smokey Robinson violated plaintiff's rights to be free from threat of violence or intimidation by threat of violence. Plaintiffs are informed and believe, and on that basis allege that defendant Smokey Robinson threatened plaintiffs with violence because they are females and were alone with him when the threats and acts of violence occurred. As a direct and proximate result of defendant Smokey Robinson's actions, plaintiffs were harmed and have suffered and continue to suffer special and general damages and extreme physical and emotional distress, humiliation, mental and physical pain, and other damages in amount to be proven at trial but not less than $50 million. Smokey Robinson's conduct constituted fraud, oppression, and or malice, and was conscious disregard of the rights and safety of plaintiffs, such as warrant the imposition of punitive damages pursuant to Civil Code Section 3294. As a further and direct result of defendant Smokey Robinson's actions as alleged herein, plaintiffs have incurred and continue to incur legal fees, costs, and other expenses in the prosecution of this matter, which they are entitled to recover. Okay, so the ninth cause of action is going to be the Bain Act by plaintiffs against defendant Smokey Robinson. Plaintiffs hereby reallege and incorporate by reference all of the above allegations as though set forth in full. Defendant Smokey Robinson interfered with or attempted to interfere with plaintiffs' clearly established rights under the United States and California law, including but not limited to plaintiffs' rights of protection from bodily restraint and harm and personal assault. Civil Code Section 43 by threats, intimidation, and coercion. During the scope of their employment, defendant Smokey Robinson intimidated plaintiffs with threats of further violence because they are females and were alone with him when the threats and acts of violence occurred. Complaint for damages. Plaintiffs reasonably believe that if they exercise their rights guaranteed by the United States and California law, defendant Smokey Robinson would have committed further violence against them in addition to the actual acts of violence as alleged herein. As a direct and proximate result of defendant Smokey Robinson's actions, plaintiffs were harmed and have suffered and continue to suffer special general damages and extreme physical and emotional distress, humiliation, mental and physical pain, and other damages and other damage and an amount to be proven at trial, but no less than $50 million. Smokey Robinson's conduct constituted fraud, oppression, and malice, and was in conscious disregard of the rights and safety of plaintiffs, such as to warrant the imposition of punitive damages pursuant to Civil Code Section 3294. As a further and direct result of defendant Smokey Robinson's actions, as alleged herein, plaintiffs have incurred and continue to incur legal fees, costs, and other expenses in the prosecution of this matter, which they are entitled to recover. So that was just number 9. Let me check in with y'all. Let me see if y'all are still here with me. Are y'all still here with me? I'm just back here reading out the documents. I'm still here, guys. Thank you all for hanging in here with me. All right, let's go. Get back into it. All right, so let's get into it. So now we're going to go to number 10. Okay, so 10th cause of action, hostile work environment as harassment by plaintiffs against all defendants. Plaintiff allege and incorporate by reference all of the above allegations as those set forth herein. For defendants conduct creating a hostile work environment for plaintiffs, making the condition of their employment intolerable in direct contravention of various statutes and state law decisions, including but not limited to California Government Code 12940H and J. Plaintiffs were subjected to a hostile work environment due to, including but not limited to, inappropriate, forceful, and offensive sexual touching, culminating in rape of the plaintiffs, as well as defendant Francis Robinson, offensive and hostile actions and language toward plaintiffs during the course of their employment. Over the course of plaintiffs' employment, plaintiffs were subjected to forceful and offensive sexual contact by unwanted touching and rape by defendant Smokey Robinson. Specifically, defendant Smokey Robinson would inappropriately touch plaintiffs, forcefully pull their blouses, pants, and skirts off, and rape them. Complaint for damages. Despite having full knowledge of the defendant Smokey Robinson's conduct, defendant Francis, Francis Robinson would rather perpetuate hostilities towards plaintiffs instead of preventing further harassment and assaults. Instead, defendant Francis Robinson thought plaintiffs' employment berated plaintiffs with derogatory racially charged epithets, assigned additional adroit, onerous tasks, and forbid plaintiffs from exercising their rights to meals and rest periods as mandated by the California Labor Code. Such harassment was so severe or pervasive that it altered the terms and conditions of plaintiffs' employment, creating a hostile, abusive work environment and making their working conditions intolerable. Said harassment was sufficiently extreme to amount to a change in terms and conditions of plaintiffs' employment. As a direct and legal result of defendants' conduct, and each of them, plaintiffs have suffered and continue to suffer general, consequential, and special damages, including but not limited to substantial losses in earnings, other employment benefits, physical injuries, physical sickness, as well as emotional distress plus medical expenses, further medical expenses, and attorney fees, all to their damage in the amounts according to proof, but in a sum not less than $50 million. Said actions justify the imposition of punitive damages in that in that defendants committed the acts alleged herein maliciously, fraudulently, and oppressively with the wrongful intention of injuring plaintiffs from improper and evil motives amounting to malice and in conscious disregard of plaintiffs' rights based upon the foregoing. Plaintiffs are entitled to recover punitive damages from defendants, and each of them in an amount according to proof. Prior to filing this complaint, plaintiffs fulfilled any legal requirements or exhausted any administrative remedy imposed on them by having filed the substance of claims alleged herein with the California Department of Civil Rights, hereinafter CRD, and has received right to sue letters from the CRD dated April 4, 2025. Plaintiffs have therefore substantially complied with all requirements for filing of this complaint and have timely exhausted her administrative remedies. Complaint for damages. So 11. Oh, child. I think let's stop at 11 and I can come back later and read 11. Okay? I think we've, because we've made like our hour mark, and I try not to make these videos like super, super long. So we'll just title this one like part one, and then we'll come back and do part two. How does that sound? It sounds good. Okay, well, listen here. I want to thank you personally for coming out and joining me as we read the court docs from the Smokey Robinson's case. Yes, Smokey Robinson has gotten himself in a little bit of trouble, child. He's in a sticky situation, and court is in session, and so, well, no, court is not in session, I don't believe, but this is just a lawsuit. Shannon Sharp is in the lawsuit. I didn't read that one yet, but then we have Diddy. Y'all already know that he's on trial. So we're covering a lot of true crimes and court stories. So I want to thank you once again for coming by. We'll see you next time. So long.